Hi, my name's Isaac Schutt. I'm an estate planning attorney. I'm licensed to practice law both in Texas and in Wyoming. And this video is actually in response to a commenter in another one of my YouTube videos where the commenter asked sort of about the interaction between a premarital and post-marital agreement versus a will and trust. And honestly, I think that's a great question. And so I said I would do a video on it. So here we go. Now, first of all, let's get something out of the way. I think that premarital and postmarital agreements, at least in Texas, are gaining a lot of popularity, and I think for good reason. I think of a premarital or postmarital agreement a lot the same as estate planning documents. You know the saying, if you don't have a will, the state of Texas has one for you. And what that means is if you don't do a will or something like that, there are default provisions who say who will inherit all of your assets when you die. It's basically up to the state law. Same goes for a premarital or postmarital agreement. If you don't have a premarital or postmarital agreement, then the state decides how your assets, your marital assets, will be distributed if you pass away or if you get divorced. And so I think it's really just good planning. It's just smart to have a premarital or postmarital agreement so that that division of assets is not left to the legislation, but instead in your own decision making, which, like I said, it's just a great idea. So I think they're gaining in popularity for good reason because people would rather make their own decisions instead of letting politicians decide what happens to their assets. And this is especially important in Texas because we're a community property state. And what that means is all of your assets that you acquired during the marriage, income assets, your paycheck and things like that, those are going to be community property. So even if you put all of your paychecks into an account with only your name on it, guess what? Your spouse owns half of that account because all that money earned during the marriage is community property. So you really want to be thoughtful about what happens if you have a dissolution of marriage or when you die, because a lot of those assets that you thought of as yours are not really yours, they're ours. Now, having gotten that out of the way, let's get to the heart of the matter, and that is, what is the interrelation between a premarital and postmarital agreement and the last will and testament or trust? Well, basically, they kind of stay in their own lane. In almost every premarital and postmarital agreement that I've seen, and certainly every one that I've drafted at my law office, states that the couple is agreeing that they will honor one another's estate planning documents. So what that means is, if you have your premarital or postmarital agreement that says, you know, if you die, your spouse will make no claim to your estate and things like that, but then you have a will over here that says your spouse inherits everything, well then your will trumps. Does that make sense? So basically, it doesn't really matter that the postmarital or premarital agreement states that you guys are sort of controlling who gets what, because it also says that you're agreeing to honor the other person's estate planning documents. And if those estate planning documents say that the other spouse gets everything, then that wins. That's what's going to happen. So I think that kind of answers the question of what is the interaction. In almost every document I've ever seen, you can kind of think of, at least in terms of the assets that you can control, okay? Your will or your trust sort of trumps whatever the premarital or post-marital agreement says, because that was your decision about what to do with your assets. So if you have a premarital or post-marital agreement, you probably have that ability to make decisions in your estate planning documents as to who's going to get what, which can include your spouse. The agreement's just going to say that they're not allowed to contest your documents. So that's typically what we see. Another thing that we see oftentimes in premarital and postmarital agreements that kind of relates to the estate planning side of things is, you know, under Texas law, the surviving spouse has certain rights to certain assets after the first spouse dies. That is regardless of whether or not that spouse, the surviving spouse, is actually inheriting anything under a will or trust. They just have certain Texas constitutional rights, like perhaps for a family allowance, which kind of feels like spousal support. They also have a right to reside in the marital residence by default after the first spouse dies. So to put a finer point on that, let's say a husband and wife have a post-marital agreement, and then the spouse has his will that says that all of his ownership in the marital residence is going to go to his kids, not the surviving wife. So the surviving wife is actually not inheriting anything under the estate. Well, under the Texas Constitution, it doesn't matter. The surviving wife would have the right to reside in that residence, even though she's not even technically the owner of that asset. So it's like the kids are the owners on paper. Great, they have a piece of paper that says they own it, but it doesn't really matter because their evil stepmother continues to reside in that property. And I'm being cheeky. I'm sure the stepmother isn't actually evil. She just wants a place to live. But in that premarital or post-marital agreement, you can actually alter those rights. So sometimes the clients will say, you know what, this is a house that the husband had inherited. It's been in the family for a long time. And so the other spouse, the wife in this example, is saying, I won't contest his will. Even if he gives up his residence, which I would normally have rights of residence in after he passes away, I'm agreeing to waive that right. So the couple could agree that she will forfeit her right to reside in that marital residence after the husband's death, and then that document will control. And if he passed away, she would have to go find another place to live. And that's actually pretty popular in our estate planning documents and premarital agreement because a lot of people don't like the default provisions where basically the kids inherit the home, but the wife gets to live in it. That's kind of an awkward situation. So in the premarital or postmarital agreement, the couple will agree to address that and say, yeah, surviving spouse, you don't automatically have that constitutional right to continue residing in that residence. You will agree to find some other place to live. And so you can kind of alter those rights that way. So I need to just kind of wrap up this video by saying, you have a lot of power as a couple. And if you don't have documents, then the state is going to decide what happens to all of your assets in their legislation. And when most people read that legislation about who gets what upon a dissolution of marriage or upon a death of a spouse, man, they're just stunned, especially when you're dealing with blended families. People just cannot believe what that legislation says. And my response to that is, you know what? That doesn't matter if you have a premarital agreement, postmarital agreement, and a will or trust. Because you're taking those decisions about what would happen upon a dissolution of marriage or a death out of the hands of the legislators and being able to make those decisions yourself. So if you already have a premarital or postmarital agreement, my suggestion to you is go through it now very carefully. If it doesn't do what you want it to do, then get with your spouse and see if you can agree upon modifications of that document. And so a lot of people, they haven't looked at their premarital, postmarital agreement for decades, and then they pull it out and they're surprised at what their own documents say. So tip number one is go back and look at your agreement so you know what they say and what abilities you have and what abilities you don't have. And if you don't like what that says, go to your spouse and see if you can come together on some agreements in modifying that document. Number two, after you look at that document, see what your rights and powers are in terms of giving away inheritances after you pass away. So 99% of the time, those documents will say that you're free to do your own will and trust, and that the other spouse will honor those documents. But look at your premarital and postmarital agreement to make sure that's what it says and that your spouse is obligated to follow what your will or trust says. And then make sure you have a will or trust. And it's totally okay if you want to give away assets in your will or trust to your other spouse. You can do that. There's no problem with that. It's just that the other spouse wouldn't be able to contest your documents. That's usually what the premarital or postmarital agreement says. So I hope that you found this video helpful. And this situation is so case by case because it depends on what your documents say. If you have a premarital or post-marital agreement, the basic law is, yeah, we're going to follow what that document says. So you need to know what your documents say. And so if you need to go consult with an attorney to get some updates done to that, I encourage you to do that. Or if you even just need help deciphering what your existing document says, go talk with an attorney to get some help turning that legalese into English for you. So I hope you found this video helpful. My name is Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming.